Mr. Cooper, can I follow up on Justice Kagan's questions earlier? Because you were discussing with her whether it should be analyzed as an expenditure or as a contribution, and you were pushing back and saying it should be an expenditure. But in your brief, you also argued, I believe, that even if the other level of scrutiny, closely drawn scrutiny, applied that attaches to other than expenditures, you still prevail. And I just wanted you to tell us why you think that.
Thank you, Your Honor. Yes, we believe that any level of heightened scrutiny, closely drawn scrutiny under contribution limits would doom this statute for the incongruities, if you will, that make it quite clear, I would submit to you, Justice Kavanaugh, that the statute itself does not advance the interest that Congress may have in preventing quid pro quo corruption. Rather, it advances the illegitimate interest of incumbent protection and equalizing and leveling the playing field. Those interests fit this Section 304 like a glove, Your Honor. The quid pro quo claim, the quid pro quo corruption costume that the government knows it has to dress this statute in, because it's the only interest that this court has accepted as sufficiently compelling to justify a drag on First Amendment rights, just doesn't fit.
Mr. Cooper, I have to say the opposite intuition. I mean, I understand the equalization argument, and if I think about it, I can understand how an equalization interest would support this law. But honestly, the thing that to me jumps off the page is that when contributors find a way to put money not in the campaign, but into a candidate's own personal pocket, when the question is contributors repaying indebtedness of the candidates so as to make the candidate himself financially better off, richer, that to me screams quid pro quo corruption interest, not equalization interest.
Well, even if you attribute that interest to this statute, it just doesn't do it in a rational way. It places no limit, Your Honor, on the pre-election contributions that a candidate may use to repay the candidate, and those alleged gifts to the candidate makes no limit on that. It only makes a limit on $250,000 of post-election contributions, and Your Honor, again, it only does that for the 87th max out contributor. It makes no sense to say that the first 86 get to make that gift. Your Honor, those gifts apply no less to every other creditor of the campaign than they apply to the candidate himself. And the idea that those gifts is just not, I would submit, a serious point. And finally, those gifts are limited by the base contribution limits that this court in McCutcheon made clear that Congress had made the judgment that they don't reflect or represent a cognizable risk of quid pro quo corruption.
So I finally got it. Your point is with $250,000, you're saying the 86 real evil